We're back on the record. Um, so our next session is going to be about ethics law, and we'll start with this ethics law training, which um, begins with defining what the ethics law is. And that's found in Florida Statutes 112.3145, and it requires that designated elected officials, including board members of special district like Holiday Park, have to complete their 4 hours of ethics training each calendar year. That's why we're here. Well, not the only reason we're here, but it, you did good then. uh, so you're required to have 4 hours of training, 2 hours of ethics, 1 hour sunshine, 1 hour public records. That's what this presentation here today is geared towards. I did want to just note the little asterisk at the bottom of this slide. I do get asked this question a lot. Um, You are not subject to training requirements in the calendar year that you are leaving office. So, just a little tidbit of information. So, administrative rule says this is what must be covered in the training, and these are the things that we're going to be going over here this afternoon. Doing business with one's own agency, conflicting employment or contractual relationships, misuse of position, disclosures or use of certain info, gifts and honoraria, post office holding restrictions, restrictions on employment of relatives, voting conflicts, financial disclosure requirements, commission procedures, the importance of and process for obtaining advisory opinion. So all of that. What is the history of this whole idea? It's that Article 2, Section 8 was adopted by the Florida voters, that's the Florida Constitution, in 1976 to provide for ethical conduct standards and disclosure requirements for public officers and employees. Specified that the legislator was to adopt the Code of Ethics for public officers. So, similar to the Sunshine Law that we already talked about and public records type issues, and the whole open government type of issue where the people should be entitled to participation, to a voice, and that the people that you elect should abide by a code of ethics that is fair and representative to the people. That's the whole idea behind all of this. So, um, the scope of the ethics law. Article 2, Section 8 of the Florida Constitution, as we already talked about, mandates ethical conduct and financial disclosure. Chapter 112 establishes the behavior and conduct standards. And then some entities can adopt, go even further if you want, and adopt what are called locally adopted rules. Those aren't covered, obviously, in the statute and the Constitution. Those are the minimums, as what's referenced there. So, Chapter 112 is really where most of the issues are going to occur, where most of the questions are going to come, where most of the things that affect the day to day operations that the board members do. This is where the tenets come out of. It's adopted in response to that constitutional mandate, legislates how public officials will meet transparency, there's that word again, and public trust requirements. So it sets forth prohibited conduct and affirmative obligations. Two overriding principles are, as I mentioned before, our same common theme of public trust and transparency. Before I get into the intricacies and the different examples, I like to say that it really comes down to if it doesn't feel right, it's not right. Okay? There's a whole host of information here. There's a quiz. We're going to go over all of it. But um, really, the tenets of the ethics law is that, as I said, if it doesn't feel right, it's not right. Guess what? You can't take bribes. Guess what? You can't misuse your public position to benefit yourself financially. I mean, a lot of these things are um, pretty straightforward. So, our first prohibited conduct, gift solicitation. So, those of you board members who were in it for not just the glory, but the gifts, you're going to have a problem. Elected officials and their spouses and children are prohibited from soliciting or accepting gifts of any value based on an understanding that the elected official would be influenced by the item. Gift is broadly defined, includes loans, rewards, future employment, favors, etc. Excludes gifts from relatives. So we're going to find that there are, and I'll get into this, there are some limits, monetary limits, on certain gifts that you could potentially accept, but you can never, ever accept anything if it's to influence you or to influence your vote. But I'm going to tell you, again, repeating what I said this morning of acting on the conservative side, it's just not worth it. I mean, I have board members around the holidays, landscape vendor or something will want to give everybody, $5 gift card to Starbucks or something like that. And they'll come to me and be like, should I take this? There's you could potentially take it as long as it's not influencing your vote. And you have to file some paperwork and things along those lines. But guess what? Buy your own coffee. Okay? It's just not worth it. It's just not worth it. Um, another second prohibited conduct, soliciting honorarium. So payment of money or anything of value given as consideration for a speech or other written or oral presentation other than a book. So I know there's not a lot of people beating down the doors to hear from Holiday Park Board of Trustees, to give speeches, but if there ever was, be mindful of that. Special district officials are prohibited from soliciting honorariums or accepting them from PACs or lobbyists who lobby the agency within 12 months. This prohibition does not include payment of actual and reasonable transportation, lodging, food, beverage related to an event. So, again, not a lot of people beating down your doors, but if you were asked to give a speech at a local event or something like that, your expenses could be paid. Next, prohibited conduct. And that's really how this is going to read. That's, as I mentioned at the beginning, the ethics laws is like a list of prohibited things that you can't do. Business with your agency. So you can't do business with your own agency. This includes two prohibitions. Public officials cannot directly or indirectly sell goods or services from the person's business to the district. Prohibition applies to businesses owned by the official's spouse, or child. So let's say that you're a board member, you've got a business of cleaning establishments. Could the district hire your business to clean the clubhouse? No. Public officials cannot act in a private capacity, renting, selling, or leasing any goods or services to their district. Again, you've got a business of maintaining landscaping. Um, you ought not to be, the district ought not to be doing business with your landscaping company. Prohibited conduct, conflicting employment. Includes two prohibitions again. Prohibits officials from having an employment or contractual relationship with a public entity that is regulated by the public entity. Prohibits officials from having an employment or contractual relationship that will create a continuing or recurring conflict of interest. So this all gets back to, you're a member of the board, you have, of course, a life, and you may have another business, something like that. You shouldn't be doing business with your agency. Misuse of position. So this prohibits officials from corruptly using position for yourself or others. Corrupt determination is based on the facts. Generally, it is interpreted as being done with a wrongful intent that is inconsistent with the official's proper performance of duty. Case law construed this to require proof that the official had noticed his or her conduct was inconsistent with the duties and a violation of the ethics code. So, you cannot say, hey, ABC Landscaping, I will vote to give you the contract if you give my son a job, if you give me $500, whatever. Again, these things are pretty self-explanatory. Next prohibited conduct, relative employment. Prohibits officials from seeking advancement or employment of relatives. And relatives has a certain definition. They're all listed in that box right there. So your third cousin once removed, you're probably going to be okay. Giving a job to your son, that's going to be a problem. You may not appoint, employ, promote, advance, or advocate for a relative in an agency position. Key is the exercise of control. Statutory definition of relative is limited to the specific familial relation. I want to get back to that second one where the key is the exercise of control. So let's assume that, and this may be the case, that Vicky hires and fires all of the staff and that the board has no control over that. You only hire and fire Vicky, okay? Then if Vicky wants to hire one of the board members' sons to do landscaping work at the park, probably going to be okay because you don't exercise control over that individual. But again, it gets back to what we've been discussing all morning in terms of appearance and things along those lines. Probably better off if there's another candidate out there to hire that person. But if you absolutely had to go that direction, purely legally, it would likely be okay. Improperly disclosing information. So you prohibits the use of information not available to the public for the benefit of yourself or others. So let's assume that, kind of hard to come up with a scenario, but let's say that doing your work as a board member, you happen upon some information that nobody else would know. You cannot use that to benefit you privately. Post office holding restrictions prohibits public officials from representing anyone before their government for 2 years after leaving office. Probably not going to come into play. Once you're off the board, you're probably running away and glad. Donna, how many years has it been? I mean, you're not good at this. um, disproportionate benefit. So you can't abuse your public position. Prohibits officials from obtaining a disproportionate benefit for yourself or others. Disproportionate benefits defined by Florida administrative rules means a benefit, privilege, exemption, or result arising from an act or omission inconsistent with the proper performance of your public duties. Violations of disproportionate benefit requires a wrongful intent through action or inaction that rises to the level of an intentional abuse of public position. So I just threw a lot at you, but again, it comes down to that gut feeling of, hey, am I doing this because it's only benefiting me? Then you probably have a problem. Prohibited conduct next is conflict. So the ethics code is premised upon maintaining public trust by prohibiting public officials from using their office for private gain. I'll talk about that in a second. Private gain generally means a public official's financial interest is directly enhanced as a result of a vote, and there's a direct and immediate gain. This is where most of the ethics opinions come about. So you are all on the board, obviously, because you, as we said, it's not for the glory and it's not for the money. It's because you want to have an impact and help your community, okay? Which is admirable, of course. So, you know, you may have something in front of you for a vote, let's say, to do some gorgeous landscaping at the entrance. Or I know you just did new security gates. So that benefits the community. That benefits you. That also, you know, potentially increases the value of your home. Does that mean that you have a conflict? No. The way that the opinions look at that is how attenuated is it? So in my example, new security measures at the front gate. That benefits pretty much everybody. And so when it's benefiting the entire community and the benefit class is this big, you're going to be okay. Let's say that you're now voting on this beautiful new fountain that's going to be just in front of the one board member's home. It's not going to benefit anybody else, and it's going to increase that board member's home by tenfold, all right? Shouldn't be voting on that because that is what they call inuring to your special private gain, and that is what the ethics opinions look at. And when it inures to your special private gain, we're gonna go through it. but there's certain things that you need to do. So, as a board member, and I think I've told you this before, but as a board member of a public entity, you are required to vote all the time. You cannot abstain. So, sometimes it'll be a simple thing. A board member will say to me, I wasn't at last month's meeting. I don't want to vote on the minutes. I'm just going to abstain. You cannot. You can vote no because you're like, I don't know what was said there. I'm going to vote no. But you cannot abstain. The only time that you can and should abstain is when you have a conflict of interest. And that is when it's inuring to your special private gain, like we said. So that awesome, grandiose fountain that's going to be in front of Sean's home, you should not vote on that. And not only should you not vote, which means that you should abstain, but then you're also required to fill out a special form called a Form 8B that says why you abstain for vote. So voting conflict means voting on a matter that will result in a special private gain or loss to the board member or person connected to them in a private capacity. So it could just be a person connected to you as well. Voting conflict does not void the vote for the board, and Florida law does not provide for a cure. A voter conflict exposes the voting board member to liability or exposure. So let's say Sean voted. Sean has a potential problem. Sorry, I'm picking on you. But has a potential problem, but it doesn't vitiate the vote. And so that fountain would still go through, but then someone could potentially file an ethics claim. Voting restriction applies when there's a specific benefit to yourself, an employer, a principal, or a relative. So as we said, it's not necessarily just you. You must abstain from voting and refrain from discussion on any measure that creates a special private gain or loss. If conflict is known, must publicly state to the assembly the nature of the conflict and abstain from the voting. There's that form I mentioned. A memorandum of voting conflict form, Form 8B, must be filed with the clerk within 15 days. What I tell my board members is if you have a concern, reach out. Contact me. I'll be glad to provide input. Another thing you can do, and we're going to get to this, is you can actually, if it's a big matter, and if it's the fountain, we would just be like, don't vote, life goes on, it's over. But if there's a big matter, um, you can also get an ethics opinion. We're going to talk about that. And sometimes that is advisable. I just had a CDD, a Community Development District, in Manatee County, where 3 of the members wanted to run for 3 open seats on the HOA. There is technically nothing that prohibits someone from being on their HOA and being on a CDD board. But there were all sorts of questions about, well, what about sunshine law? What about that they're now 3 people could be a 3-vote, it was a 5-member HOA board, could be a voting block. And so there were all sorts of issues swirling around. It was very important to the community. We needed to, quote, get it right. So we actually requested an opinion from the Florida Commission on Ethics. By the way, they allowed it, and then all 3 of them lost the election. But that was something that had huge impact on the community as a whole. It was worthwhile to get an opinion. And the Florida Commission on Ethics is glad to issue those. And they did it fairly quickly within a few weeks. So there are forms for ensuring transparency. There's the Form 8B, which we just talked about. There's the Form 1, which you board members all know that you file every year with your financial disclosures. It's not too intrusive. I mean, you don't have to list exact amounts in pennies and things along those lines. But you do have some disclosures you need to do. And on that Form 1 is where you check the box that you completed this training. There's a Form 9, quarterly gift disclosure if you're taking gifts, which again, I said there's really no reason that you need to do that. And Form 30, a donor's quarterly gift disclosure. So this next slide is just a copy of what the Form 8B looks like if you did have that conflict. You basically fill it out, who you are, what the vote was about, and as we said, you provide that to the clerk. It gets attached to the minutes of that meeting where you abstain from voting. Then there's the Form 1, as we talked about, that elected and appointed special district officials must fill out. annually on or before July 1. They're serious about that, okay? And I know everybody does it on time, but there are penalties that happen if you don't do it by then. So make sure that you do it. There was a little bit of a hubbub in the news a couple years ago, you might remember, where there was a push to make special district board members, like you are, file a more detailed form, more than the Form 1, something that some other like county officials and such need to do. And a lot of people were up in arms of like, why am I doing this? Why should I have to disclose all this information? And it did not pass. So all you have to do still, and nothing came up in the past couple of years in the legislature. So I think it's hopefully a dead issue. You're just stuck with this Form 1, which is not too burdensome. Requires the reporting of person's sources and types of financial interest. Does not require monetary values. Now, within the past year or so, must be filed electronically, must file within 30 days of appointment. And then there's a Form 1F. So if you do exit the board, then within 60 days of leaving the position, you need to file that Form 1F. Here's just a snapshot of the website. I don't know when the Commission on Ethics sends it to you, but I believe they send it to directly to your email address. So here, and you can always, if you think you missed it or something like that, I mean, start with Vicky. But if there's some reason you still have questions, the Commission on Ethics is very accessible. In fact, what I'm going to get to is we're going to say, okay, they might be what some will say too accessible, because what we're going to get to is it's pretty easy to file an ethics complaint. Here's just a few more slides on showing the filing. If Form 1 is not filed by September 1, automatic fines accrue at $25 a day with a max penalty of $1,500. Fines may be appealed but can only be waived by the Commission on Ethics for unusual circumstances, and that commission can investigate officials for failure to file and can result in removal of office. So like I said, for whatever reason, they're really serious about this. Um, this is a little bit about the Form 9 and 30. Again, probably won't come into play for you, but elected officials may accept gifts valued between $25 and $100 from a vendor lobbyist doing business with the agency, but the gift must be reported by the donor and the reporting official. So getting back to that coffee gift card, as long as it's not to influence your decision, you can never take anything for that. As long as it's not to influence your decision, you could take it. I'll say it was $30 to make this example easier. But and then you got to file a disclosure form, and like I said, buy your own coffee. Gifts valued over $100 require disclosure on the quarterly gift disclosure Form 9. And there's no obligation to file a gift disclosure Form 9 if you've not received a gift, like I said. This next chart is, or this next slide is a pretty good little chart. I'm not going to go through it in total, but it's sort of a flow chart of how this works. Is this, then go here. Is this that, then go there. If no, then you're good. That types of thing. So how is this all governed? I keep referring to them, but it's the Florida Commission on Ethics. And the Florida Commission on Ethics was created to investigate complaints and breaches of public trust. It's a 9-member commission that serves 2-year terms. There's the makeup: 5 by the governor, 2 by the president of the Senate, 2 by the Speaker, the House. Members are not permitted to hold public employment during their terms, and they meet in Tallahassee. So there was a historical sample of what the commission looked like at that time. But they render legal advisory opinions to public officials seeking guidance. They have jurisdiction to review and investigate ethics complaints against individual public officers and employees for violations of the code. They cannot conduct an investigation until a sworn complaint is filed. They do not independently initiate an action, even if there are newspaper articles, letters, or phone calls. So there might be a big story in the paper about all of the corruptness at Holiday Park, and the Florida Commission on Ethics is not going to initiate an investigation on their own. But If a resident, or really anybody, wanted to file a complaint, they would investigate it. And it's pretty darn easy to file a complaint. So, like we talked about before, you want to be careful with sunshine and public records issues. Not that you wouldn't, but you want to be careful with ethics issues. Doesn't mean it has merit, but it's very, very, very easy to file a complaint. They happen all the time, more than you might think. A lot of them get dismissed right off the bat, but they happen. So, the Ethics Commission will investigate a complaint and then issue an opinion on it. But the other thing they do is what I alluded to before, is that they could give advisory opinions. To the example that I just gave before, which is legally binding advisory opinions may be sought from public officers, employees, or candidates from the Florida Commission on Ethics. Advisory opinions are binding on the conduct of the person who is subject to the opinion. Once issued and followed, the opinion provides a type of immunity from an ethics complaint for the individual seeking the direction. So in my example of this district in Manatee County, the chair asked for the ethics opinion, and we got the opinion that I think he wanted, which was that he was available to run for the HOA board seat. And so that way, if someone filed an ethics complaint and said, you can't do that, he could wave that around. Doesn't necessarily, it's not court. So, it's not a court decision. It's not the final word. But if it ever ended up in court, him waving that around would have pretty much taken care of the case. So it has definite value. But the other thing I tell people is be careful what you ask for. So don't ask a question that you don't want the wrong answer to. This is not for park and recreation districts, but again, I represent a lot of what are called community development districts, CDDs. And there is CDDs use a lot of my communities use money to say, hey, we have some funds, we'd like to do holiday decorations. Everybody does holiday decorations, or throw a party for our residents, etc. Someone, I don't know why, asked whether they could do that, ask for a formal opinion. And guess what? It's not specifically listed in the statute. They came back and said, you can't. But why would you even ask that question? I mean, just something like that is something you might just go ahead and do. So all that to say, be careful what you ask for. An administrative complaint can be filed with the Florida Commission on Ethics. Complaints are the easiest type of action to file, like we said. The form is available right on the website. It's investigated by an investigator. 99%, I don't know if this is a true figure, but 99% of them are dismissed. But if they do find that probable cause exists, an administrative hearing is scheduled before the panel in Tallahassee to determine the violation. The Ethics Commission conducts a hearing, decides whether there was a violation, and recommends a penalty. So here is a copy of the complaint form. As I said, you can grab it right off the website. It's pretty easy to fill out. There's no filing fee. Once filed, the complaint and all the proceedings and records are confidential until the respondent requests it be made public or the action before the commission is before the commission in a public hearing setting. 5-year statute of limitations on ethics complaints. Commission can dismiss small minor violations. So as I said, most of them don't even get to the commission because they don't find probable cause. Then even when they do, the commission can dismiss them, or they could potentially find a problem. We had a judge in Manatee County that had a problem, had accepted some baseball tickets from a couple of attorneys who had a case pending right before him at that time. So again, it gets back to your gut. It's like, did that sound like a good idea? Probably not. He should have bought his own baseball ticket. And he ended up getting sanctioned. Potential penalties: removal or suspension from office, impeachment, censure, reprimand, demotion, or salary reduction. I mean, they could cut your salary in half. Forfeiture of a maximum, exactly. forfeiture of a max of 1/3 of your public salary, restitution, civil penalties up to 20,000. I mean, that's significant. For gift violations, up to 3 times the value of the gift, and fines. So here is a real life example. Those of you who might remember this one. This is up in my neck of the woods in Manatee County. We had a county commissioner who, this was during COVID, and everybody was on edge, of course. And she misused her public position to get some special benefits for her and some of her friends. And they sanctioned her and fined her. And she eventually left office. So we have an oath of office, just like I read earlier. It says, I do solemnly swear or affirm that I will support, protect, and defend the Constitution and government of the United States. I'm not going to read it again, but it's the same oath. That's what all this is based on. Indemnification. So we touched on this a little bit when we began this conversation. You have, as a public official, you have most likely insurance that will cover you if you're acting within your fiduciary duty. You have the right to be defended if you're acting within your fiduciary duty and if you are doing what is ethical. So a lot of times what will happen is you might get action filed against you if you're ultimately determined there's no probable cause. Then usually the district will provide a defense. If you're ultimately decided no probable cause, you'll be fine and you won't have to pay anything. If there is probable cause, you potentially would have to reimburse the district for the attorney's fees that were incurred. So all of this to say, act within your fiduciary duty. I mean, mistakes happen, but some of these things that we've talked about are pretty obvious, and even if they weren't obvious, they've now been explained to you. So you're now on notice, which is another potential problem. When Andy stood before you and said, don't take a bribe, and then you do, it's going to be hard to defend. So we said these complaints are easy. What happens if ethics complaint is filed against you? Don't panic. They're confidential until the case is over. Call your district's legal counsel. We can help. Filing of the complaint does not mean it will move forward. Like we said, a great majority of them don't. If it does, find out whether your district will provide a defense. Inquire into insurance coverage. And you may want to obtain independent legal counsel. So next part of the presentation is a little quiz that I've prepared, a little more extensive than the others. But before we go to that, I'm glad to try and answer any questions. All right. So this is the next handout, the ethics law training, ethics law quiz. I gotta take some water. These are long questions. So for the past 4.5 years, ABC Water Control District has had a 5-year maintenance contract with the Big Green Machine, a nationally owned lawn and tractor retail and repair shop. The contract is due to expire in the next 6 months, and the district manager informs the board that they will need to decide whether to extend the existing contract or competitively bid out a contract with a new vendor for a new term. None of the current board members served on the board 4.5 years ago when the contract was awarded. Big Green Machine's owner, Sal Salesperson, has recently started attending all the district's monthly meetings and introduced himself to all the district's board. After last month's meeting, Sal invites the chair to join him for a night on the town with a chauffeured limo ride, dinner at Burns, and then a Kenny Chesney concert. That sounds good. At the end of the evening, the chairman offers to repay Sal for the night's entertainment, limo ride, dinner, and the concert ticket. Sal replies, "Don't worry, friend. You'll be able to reciprocate." So, which of the following is the most accurate statement? B. The chairman should pay his own way for his evening out with Sal to avoid any claims that Sal influenced the decision-making process relating to the district's lawn and tractor maintenance contract. All right, so what does this question get at? This question emphasizes that public officials should not solicit or accept gifts or things of value when they are being given the gifting of value to influence their vote. This scenario also emphasizes the ethics code's anti bribery position that prohibits things of value being offered as a quid pro quo. Question 2, a little shorter. Using all of the same facts outlined in one above, assume the value of the limo ride, dinner, and concert ticket was worth a total value of only $95. Which of the following is the most accurate statement relating to Florida's ethics law? The answer is D, as in dog. The chairman should still pay his own way for his evening out to avoid any claims that Sal provided the chair with an unauthorized gift to influence the district's board decision on the lawn and tractor contract. So this gets to that. Even if it's a dollar, even if it's 50 cents, can't take it if it's given to influence your decision. Violates the anti-bribery provision. Question 3. Paulina Principal is an employee of the Padre Municipal Improvement District, the PMID. Paulina rents an apartment and is a registered voter within the PMID. Paulina is displeased with the recent policy decisions of the PMID's commission relating to infrastructure funding priorities. The chair of PMID's commission is up for re-election. Paulina believes it is her duty to run against him and unseat him to effectuate the much-needed change on the commission. Which of the following is the most accurate statement about Florida's ethics law? This is B. Paulina can serve as an employee of PMID and as an elected official, but only if she is serving as an elected official at a special district other than the PMID. So this is public employees are prohibited from being a member of the governing body which serves as their employer. So Vicky, you can't run for the board. Sorry. Question 4. Bill has been a licensed realtor with the county for over 25 years. Bill was recently appointed to the fire commission to fill a vacancy. After accepting the appointment, Bill meets with the fire chief, who tells Bill about the district's need to acquire property to meet the district's response time and growth needs. Bill asks the fire chief how much the fire district has to spend on the real property. The fire chief replies, "We have budgeted $750, but if we had to, we could shift funds around and spend up to 8.25." After talking to the fire chief, Bill contacts one of his former clients who owns the perfect property for the district's station needs and asks if the property is for sale. The former client asks Bill how much is being offered. Bill tells his former client about his discussion with the fire chief and indicates that the district can spend 8.25. Which of the following is an accurate statement? A. Bill has violated the ethics law and misused his position by using confidential information to benefit his former client. So even though it's the perfect property, it's be a benefit to the fire commission, still a problem here. Public officials are prohibited from corruptly using or attempting to use their position or resources to obtain a special privilege, benefit, or exemption for themselves or others. Regardless of the fact that the district needs to acquire the property, Bill is using info he obtained from the fire chief to help his former real estate client sell his property to the district for a price that is at the district's upper end of its budget. This information from the chief about the available funds is not otherwise available to the general public. So there's like 2 or 3 things there that Bill screwed up on. Bill is a licensed realtor with his own real estate firm. Here he is again. He was recently elected to the fire commission. He meets the fire chief. Um, meets the fire chief and is told about the fire district's difficulty finding a property for a new fire station. Similar facts. After the meeting, Bill gets to work and locates the perfect property. He approaches the current property owner about whether the property is for sale. The current property owner advised Bill that everything is for sale. Being mindful that he was just elected to office, he was trying to be good, he asked an associate real estate agent to handle the matter. The colleague fills out the sales contract and sets a fair purchase price. Bill's colleague keeps the standard 6% realtor commission. fee provision in the contract because Bill's real estate firm put this transaction together. The entire fire commission considers this purchase a great deal. So it's a good deal, it's perfect property. He's not dealing with it personally. Is it okay? No. D. Bill violated Florida's ethics law because as a partial owner of the real estate firm, he's prohibited from doing business with the district. All right, moving along. Question 6. Johnny Johnson has a private lawn care and landscaping business named Mowers R Us. He has owned this business for over 5 years and has recently decided to expand the business to pursue larger contracts. Unbeknownst to Johnny, Johnny's brother Jimmy was recently elected to the Board of Trustees of the Green Acres Park and Recreation District. Sounds like a good place. The Green Acres District has gone out to bid for a new lawn care and landscaping contractor. Mowers R Us is one of 6 local vendors that has bid on the contract. Mowers R Us has submitted the lowest bid price. The award of the lawn care contract will be selected by the Green Acres District Board at the next meeting. Which of the following is an accurate statement about Florida ethics laws? C. At the meeting where the contract will be awarded, Supervisor Jimmy Johnson must publicly disclose the conflict of interest, like we talked about, abstain from voting, and file a memo of voting conflict. So, when the conflict occurs, as we said, you have to publicly announce it. So you're at the board meeting, you go, I'm Andy Cohen. I'm going to abstain from this vote because I have a conflict. This is what it is, and I'm going to fill out this Form 8B, and it's going to be incorporated. That's the way it goes down. A few more comics. Question 7. A violation of Florida's ethics law is subject to the following penalties. The answer is E. All of the above. So, impeachment, removal of office, censure, demotion, penalties, all bad stuff, which we hopefully don't have to worry about. A couple more comics. To our next question, 8. Lavender Chill and her husband Isaac live in the Beach City Library District. Lavender's husband is the owner of an AC company, We Cool You. We Cool You has had a long-standing AC maintenance contract with most of the public and private commercial properties within Beach City, including the library district. There was a recent vacancy on the district board, and Lavender was appointed to fill the vacancy. Select the most accurate statement. Answer is E. So it's B and D. Lavender may serve on the board regardless of her spouse's company contract with the district if the award of the contract occurred through a sealed procurement process that Lavender was not involved in. So here, a little bit of an exception because she's not involved in the process at all. And then D, she could serve on the board as long as the contract with her spouse's company does not create a continuing, reoccurring conflict. So she wasn't involved in the decision, and then she wouldn't have any voting authority or anything like that into the future. Let's see. I wanted to read that. There is a grandfathering exemption to the prohibition on doing business with one's own agency if there's an existing contract entered into prior to taking the office. However, changes in a contract after assuming office is deemed a new contract that is not subject to the exemption. The Ethics Code prohibits public officials from having a contractual relationship that would create a continued or reoccurring conflict of interest that impedes the full and faithful discharge of duties. When the contract for business is awarded pursuant to a sealed competitive bid process that the official has not participated in, there is an exemption to the restriction on entering into a contract with an official's relative. So that particular question touched on a number of different concepts. One being that if you're not participating, or if there's a sealed bid process, there's a potential exemption. There's a potential grandfather if that took place before you got there, and then you have no further involvement in it. I did have a district once where the individual owned a pump maintenance company, and they had an irrigation pump, and his company was voted upon to be the company to maintain the pump before he ever got on the board. There was no problem there. Then he joined the board, and the question was, well, can he still continue to do it? Well, there were continuous um, work that needed to be done on these pumps, and they were awarding things. It seemed like almost monthly to the pump company to do work on it. And someone raised an issue and filed an ethics complaint against this board member and said he had a continuing conflict. And the ethics commission actually found him in violation. And the district, he was fined, and the district terminated his contract with that company. Bonus question. When in doubt of my obligations under Florida's ethics laws, I can contact the district's attorney for advice on the law. As long as I follow that advice, I am insulated from all liability. False. While the district's attorney can provide advice and recommendations, when in doubt of an obligation under the ethics code, the only way to fully insulate yourself from liability is to obtain an ethics opinion. And as we said, that won't fully, because it's not a court decision, but as close as you can get to insulating them. So I think we're done early, but I'm glad to answer any questions that anybody has. All right. Thank you, everybody. I appreciate it. Thank you for lunch.